Good morning, council. This is case number 121620, Patricia Nicholson versus Ava Marie Mercer. I would say that this is an appeal from Leavenworth District Court. I would ask council to please enter their appearances. We'll hear from the appellant.
This is James Maloney for Key Insurance Company.
Thank you, Your Honor. LJ Leatherman on behalf of Patricia Nicholson and the heirs of Mark Nicholson.
All right. Council, I don't know how we line up on your screens. To my left is Judge Bruns and to my right is Judge Schroeder. And we're lucky enough to be your panel today to hear this appeal. We have read your briefs. We have received a pre-hearing memo from our research staff concerning the case. And I think we're up to speed on what is at issue. So we are eagerly awaiting your oral arguments so you can educate us on what we need to do in deciding this appeal. The appellant, counsel, do you wish to save any time for rebuttal?
Yes, Your Honor, I'd like to reserve 5 minutes for rebuttal.
You've got it. We'll take care of that. And let's proceed then. We'll hear from the counsel for appellant.
Thank you, Your Honor. May it please the court. This case comes from a June 2017 accident in which Ava Mercer was driving her car in Leavenworth and unfortunately collided with a bicycle that was being ridden by Mr. Nicholson. Mr. Nicholson unfortunately passed away as a result of that accident. As I mentioned, that accident occurred in June of 2017. Key Insurance Company, which insured Ava Mercer, began investigating this accident, and it spoke to 3 independent, uninterested eyewitnesses who told both Key Insurance Company and the Leavenworth police that the bicyclist, Mr. Nicholson, had swerved in front of Ms. Mercer's vehicle such that no fault should be attributed to her. That was the information that Key had at that time. Key accepted coverage for Ms. Mercer's alleged liability, and when suit was filed in January 2018, Key provided an attorney to defend her. First, that was an attorney named Frank Hummer, and later he was succeeded by an attorney named Jace Fletcher. As that litigation went on, with 3 favorable eyewitnesses still talking about how Ms. Mercer did not cause this accident, Key received notice from Mr. Fletcher, who represented Ms. Mercer at that time, that she had entered into an agreement with the plaintiff, specifically a contract or a covenant not to execute. And as part of that, Mr. Fletcher told Key that he was no longer going to present any defense for Ms. Mercer. Essentially, he was now going to be cooperating with the plaintiff rather than cooperating with Key Insurance Company. Now, Ms. Mercer had a duty to cooperate with Key, but in this agreement, she decided she was going to cooperate instead with her adversary. Key got notice of that agreement and counsel's intentions on Thursday, May 23rd, 2019. It filed its motion to intervene the very next Tuesday, May 28th, 2019. Judge King ultimately held a hearing on this and denied that motion, for best that I can understand, on the basis that he would not be bound by the judgment entered against Ava Mercer. Here today, the issue is this. Under KSA 60-224, did Key demonstrate that it was entitled to intervene in the case? And there are 3 prongs of that. Was its application timely? Did it have a substantial interest in the subject matter of the case? And was there lack of adequate representation of that interest? Beginning with substantial interest, I'm not sure how anyone could deny that a liability insurer for a tortfeasor in a lawsuit has no interest in that case. Now, there is frankly not much case law discussing this issue in this context. There are two federal cases cited in the briefing. One is
question.
yes.
You mentioned two attorneys were hired to represent the driver in this situation. Were those in-house counsel or are they independent counsel?
They are, my understanding, Your Honor, is that they effectively operate as in-house or what is sometimes called captive counsel.
All right, so they were employees of Key.
That's correct.
All right, and that's both of them.
Yes, and to be a little bit more precise, they are employees, my understanding, of Med James Inc., which is the owner of Key Insurance Company.
All right, so then your motion to intervene was denied.
Correct.
So would you have intervened as Key Insurance as the party or in behalf or under the name of Miss Mercer?
We were asking to intervene as Key Insurance Company, not for the purposes of litigating coverage or any alleged bad faith, but for purposes of presenting the defense that we had hoped defense counsel for Ms. Mercer would present.
All right, and so you would have presented your name as Key Insurance before the jury if you'd gone to a jury trial.
That would be the situation, yes.
All right, so my next question is, you were denied the right to intervene, and you apparently knew that the trial was set in a matter of days for the fact question and liability before the district court in a bench trial. Is that true?
Yes, Your Honor.
All right, so why didn't you file an appeal bond or ask the district court for an appeal bond or the appellate court once you filed your notice of appeal for a stay order?
Well, Your Honor, had we obtained an appeal bond, what would have happened is we would have been potentially making ourselves on the hook for the entire amount of the judgment. So to do that, we would effectively have to concede the alleged negligence or bad faith in failing to settle.
But at that time, there was no judgment. So wouldn't it have been a discretionary call for the district court to set the amount of the bond?
I don't know the answer to that, Your Honor. I will say that as a non-party, I'm not sure we would have any ability to seek a stay of that case because once the intervention was denied, we were not a party withstanding to make that sort of a motion.
You're saying you have the right to intervene. So why wouldn't you have a right to seek a bond to stop the proceedings from going further?
My understanding of the law is that because the intervention was denied, we were then not a party withstanding to take further action in the case. We would have had to intervene in order to do those things.
All right. And if you didn't have standing at that point, how do you have standing to challenge the validity of the verdict below?
Well, our position is that because the motion to intervene was improperly denied, the case should not have gone forward without Key Insurance Company as a party. And on that basis, the judgment that was entered on the wrongful death claim should be reversed.
And just so it's clear, counsel, you moved to intervene as a matter of right.
Correct.
And that is a final appealable order pursuant to Kansas law, is it not?
Yes, it is.
And do you have any obligation to seek a stay?
Not to my knowledge. The case law that I have found does not require us to seek a stay in order to appeal the denial of our motion to intervene.
And the reason why this has not come up in this context before is because usually these cases come up either where an insurer is defending under a reservation of rights, correct?
Correct, or has denied coverage outright.
Or is completely trying to avoid the situation. We go ahead and have a bench trial, we determine the damages and let them fight it out later. But here, your company had accepted its duty to defend and was not defending under a reservation of rights. Is that correct?
Correct. It was defending without a reservation of rights with the intent of presenting a defense of Ava Mercer when the wrongful death case went to trial. That would have
Now,
been
it
done
appears
through,
go ahead.
that would have been done through defense counsel had there not been the agreement with the plaintiff.
It appears that Judge King hung his hat heavily on an answer by Mr. Leatherman to a question that he asked. He asked, what do you understand Key is able to do in that garnishment action by way of defense? And Mr. Leatherman said, quote, they can raise all the same defenses that they could raise here if they are allowed in, period, close quote. Can you raise these defenses in the garnishment action? And if so, doesn't that take care of any prejudice that might have resulted by the failure to allow you to intervene?
Your Honor, we have a motion pending in the garnishment action that will answer that question. Whether Judge King allows us to do that, or as we've set it up, whether Judge King says, no, we are not bound by that judgment and it's not enforceable against us. But that motion is pending.
So this could all be moot if he rules consistent with Davin versus Athletic Club of Overland Park, which is now Justice Rosen's case, in which he said, quote, parties to litigation cannot concoct a scheme agreeing to a declaration of negligence and judgment and then expect the insurance company to be bound by that agreement without being able to defend itself against the liability, period, close quote. If he goes along with that, this whole appeal is moot, isn't it?
I think it would be, Your Honor, but we don't have the answer to that question yet.
Well, if Mr. Leatherman will stipulate to that, it seems like you could resolve this case and you would not need an opinion in this particular case. Everybody has their day in court, and if he can prove a $2 million judgment and whatever fault there is, it seems like, because what we're really looking for, it seems like, is fairness in this case.
You're right, Your Honor. I agree 100% what we're asking for is fairness. And I agree 100% that if Mr. Leatherman and his client would stipulate that we're not bound by this judgment.
Are they opposing that motion?
They have not yet filed a response to the motion, but Your Honor,
I'll ask Mr. Leatherman if because if he's not, it seems like perhaps this whole thing, we're just wasting everybody's time and effort with this thing. Right. But in any event, since we're here, go ahead and complete your argument.
Your Honor, in further
counsel, let me point out to you that you're into your rebuttal time now.
Oh, okay. I would like to answer Judge Bruns' question a little bit further, and that relates to this hypothetical stipulation. I did have communication with Mr. Leatherman before we got into heavy briefing on the appeal, because I agree. If they would stipulate that we're not bound by that, we don't need to appeal the denial of the motion to intervene, because we would get our day in court through not being bound and essentially retrying the wrongful death case. But Mr. Leatherman and his client took the position that no, that's not what they would agree to. And now how they're going to respond to our pending motion, I'm not sure. I'll wrap up very briefly because I'm into my rebuttal time. There are two federal cases that address this exact issue and say it's obvious that an insurance company in this situation has an interest in the case and should be allowed to intervene. Those are the Design Basics and Campbell cases that are cited in the briefs. I'm not aware of a Court of Appeals or Supreme Court case making that same ruling. However, in the Gruber versus Estate of Marshall case that this court decided earlier this year, the court noted that the insurance company could have intervened in order to protect its interest in the outcome of that case. Now, I happened to listen to the argument that preceded this one, and Judge Hill made a distinction between dicta that's made in passing and dicta that's intended to be some sort of guidance. And I read, to the extent that those statements in the Gruber opinion are dicta, I read those as the kind that's supposed to be guidance going forward, and would say
you have the benefit of the author of that dicta on this panel, I believe.
I
Judge Hill
realize
wrote the Gruber decision.
That Judge Hill wrote that and is sitting there, and he may be thinking that I'm completely wrong in my assumption, but I would urge him to agree with me on that. And that'll conclude my opening remarks. If I have any time left, I'll save that for rebuttal.
Fine, you've got your rebuttal time, counsel.
Thank you, Your Honors, and good morning. LJ Leatherman on behalf of Patricia Nicholson and the heirs of Mark Nicholson. I think that we're on the right point here, and that is that if Key Insurance wanted, first point at is that if Key Insurance wanted to contest this judgment, they needed to file an appellate bond, or at a minimum, make an application for an appellate bond. When he says, well, that would be making us responsible for the entire judgment, it's not the way the appellate bond works. The appellate bond is to protect my client so that my client's assets are not wasted by the defendant, and so that we can preserve it or begin collections. And by not filing the appellate bond, they have put my client at risk. Absolutely, as an appellee or an appellant in a case, as an intervener, if they want to stop that judgment from becoming final, they need to file that appellate bond. The judgment time has run, the judgment is final, and this is all moot. On the second issue raised during the previous oral arguments, the reason it does not matter that they are not there are really twofold. And the case law is long in Kansas, beginning with Glenn versus Fleming, which is we're all very familiar with. It doesn't matter what the plaintiff and defendant do in a tort action, because all of their actions will be reviewed by a district court to determine if there was any collusion or any fraud or any misdealings as described by Justice Rosen. They are not bound by this judgment unless they committed bad faith. And that is a question being dealt with in the district court by Judge King. If he determines...
So Mr. Leatherman, I think you and I are on the same track on that, other than I want to make clear, because I read the quote, which you said, and then Judge King went on and said, will they be able to contest liability? And you said, yes, I believe so, yes. Will they be able to contest damages? And you said, yes. If that's true, are you willing to stipulate that those issues can be resolved in the garnishment action, and then this case becomes moot?
I am, and I want to be clear because there seems to be confusion from that quote in context with Judge King. Their defenses are collusion, that somehow we tricked them.
No, and I recognize that, and they have every right to bring that up. What I'm more concerned as, do they have the right to continue to bring up comparative fault and the damages, which is what I think Judge Rosen, who was my colleague on the Shawnee County bench at the time when he wrote that opinion, now Justice Rosen, was trying to get at. In fairness, liability, if the insurance company should be able to raise it at some point. So he talks about these three witnesses, and those witnesses may or may not say what he claims they're going to say. Something tells me you probably would cross-examine them. But at least they have the day in court on liability, which would include comparative fault and damages. And I recognize the whole bad faith thing and whatever. Mm-hmm. That's really not what I'm concerned with. Will they have the opportunity in the garnishment action to assert comparative fault and amount of damages?
Within the context of the contract and bad faith, yes. He can come in and say, they didn't tell you about these witnesses, and that's how we tricked them into doing this. So they can contest that liability isn't what it was decided before because there was collusion on liability. He can say those damages aren't right because they colluded on the damages and they didn't tell you about this. There was collusion. So the burden of proof is different, but the ability to contest exists.
So then are you actually telling us that this case is moot? Because that door is open with the pending motion in Leavenworth County.
Correct.
Do we know when that will be? What's the deadline on that?
We, I believe, are filing our brief. Mr. Van Dyke is handling that, and he's negotiated with Mr. Maloney, but we're within the 10, 12 days of that being heard. We're going to trial in June, I believe. So the motion pending is a summary judgment filed by Mr. Maloney saying that they're not responsible for this and contesting it, and we're going to trial in June. And knowing Judge King, I believe that trial will go forward.
So at that trial, then Key Insurance can bring in their expert to testify about the reasonableness of damages.
They could, except they filed a motion that experts are inappropriate. So that motion is also pending in front of the judge. We've retained an expert on insurance, and they filed a motion that experts are inappropriate because the district court is knowledgeable as to the law and facts.
Well, to get back to our case,
Yes.
basically we have simply an issue of whether or not the insurance company had the right to intervene. And it was denied. And that's solely the issue that we have, isn't it?
It is. Well, I mean,
that seems to me a pretty simple question to answer.
Under Glenn versus Fleming, I do too. And at Griggs, and yes.
What about Gannon
Right
versus
intervene.
State that said that the Supreme Court says that we've held that KSA 60-224A is to be liberally construed in favor of intervention?
That it's a legislative choice on what is a right to intervene. The legislature has been aware of Glenn versus Fleming since 1976, when my senior partner and other members of Judge Brunn's firm fought that out, and they have done nothing to change it, which indicates to me that they don't want a right to intervene by insurance carriers. In this case, we have a trial set. We have commenced discovery. I have not been at all of them. I've been deposed. I think there are about 25 depositions. All those factual questions are in front of Judge King. If there's collusion in this case, and if we colluded on damages or if we colluded on liability, Mr. Maloney has an opportunity to do that and is exercising that opportunity right now.
Let's take collusion out of it. What Judge Rosen said was they have the right to defend themselves against the liability. Do you agree with that? Whether there was collusion or not. I mean, I don't think there's collusion. This lady was trying to take care of herself and protect herself. And she maybe had a duty to cooperate, but that's a different issue. The way I read Davin versus Athletic Club of Overland Park is they have the right to defend themselves at some point, either earlier or now, against the liability.
Yes, they get to bring in fact witnesses as to why they believe there's no liability. Because the question is, they say, we don't think she was going to be at fault. And they risk, it is a $25,000 policy when you killed I believe, 61-year-old retired lieutenant colonel who's actively employed. And they have to weigh that risk. And they said, you know what, let's risk Miss Mercer's assets, because we think that this will never occur. And that put her at risk. And therefore, when we come back at the district court with Judge King, he's going to look at liability and say, was that reasonable? And is what they put on as evidence reasonable? And all those witnesses, all the fact witnesses have been deposed. I don't believe all the expert witnesses have been deposed, but I have been deposed. All the people here are going to testify in front of Judge King and say, here you go. And if they prove that she wasn't really liable because of collusion on our part, then they're not responsible. That's their day.
What if they prove that Mr. Nicholson was 40% at fault? That would reduce the judgment, would it not?
That would eliminate it, because they would prove collusion. Because to get there, we would have had to collude it to get the wrong answer.
No, because the judge decided the amount of comparative fault.
The judge,
you presented your case and the judge found 100% fault, but they weren't there to defend it. If they still have the right to defend liability, then the judge could say, okay, now that I've heard these three witnesses, I find that Mr. Nicholson was 20% at fault. They only have to pay 80% versus 100%. That's different than collusion. Collusion would be that you got together, did something wrong, and agreed on some. That's not what you did. You went, and I know you did it in front of me several times, had a bench trial, presented your evidence, the judge ruled. They just have a right to present their defense.
I don't believe, yes, your Judge Hill.
It seems to me that there's a difference between a defense for somebody accused of a tort and the defense of an insurer wanting to keep not from paying on the policy.
Yes,
And it's too easy to get those concepts mixed up because those are different questions. Whether there is a factual basis for a tortfeasor's liability is one question. Whether or not there's a contract obligation to pay for an insured's liability is another. And there are different defenses to both, correct?
correct. And
And what is being taken up in some other action in front of Judge King is not a question that we have before us here.
All due
correct,
respect to my colleague, I think it is, because he specifically in your own brief cites this representation that you made to the court in
Yes.
which all the same defenses, so comparative fault, nature and extent of damages. And then he goes on and to clarify that with you. And he says, they're able to contest liability. You said they were. They're able to contest damages. They said they were. It seems to me Judge King ruled the way he did based in large part upon the representations. And I think they were accurate representations made to the court. So I do, with all due respect, I think that this issue is exactly before us because that's what Judge King had in front of him when he denied the motion to intervene as a matter of right.
I would say that Judge King, and if you read back in the parts quoted in our brief, we were on the same page that whatever defenses Key has don't change. And therefore, whatever they are, they can be decided in the garnishment. Whether
Including
I'm right or
comparative
wrong
fault
about
and
the law.
damages.
I
Including
apologize.
comparative fault and damages.
Yes, but the test is whether we colluded on comparative fault or damages. Did we, because
So
if,
those aren't all the defenses. As Judge Hill just pointed out, that's a separate issue. And
All
what
the
Judge King was
defenses
trying
they-
to find out is were they going to be able to present these defenses at some point? And he denied this motion to intervene, and it seems like because he believed that they would be able to do that. And collusion's a different issue.
he got the answer correct under Glenn versus Fleming. And I don't
Well,
believe,
if Glenn versus, I agree with you, Glenn versus Fleming is still the law, but it doesn't address this specific issue. I mean, this is very different than what we've had in the past. This is not under a reservations of right. This is not a denial by an insurance company where they're just trying to avoid completely their obligation. They came in and defended the case. So this is very different posture from any of the cases we've had in Kansas before.
within Nungesser, Justice, I'm drawing a total blank. In Nungesser, and I will get you the justice's name in a moment, when they ruled that the insurance company could not be pled in by a third party, and they sent Nungesser all the way back to the beginning to say it is a separate action, either in garnishment or by direct action. And I believe that they were clear in that you can't split a cause of action. There are not two causes of action in a tort case. There's the plaintiff versus the defendant, and Key Insurance coming in, and we have this trial where Ms. Mercer's defended and the insurance carrier is coming in and saying, well, we realize this over here, but we want to talk to you about that. There's no place in a tort action for this insurance carrier to be named. I don't know how I am on time.
You've got about 1 minute.
Okay. They've created this very bizarre procedural issue. They have not preserved the issue properly by not filing an appellate bond. And the issues raised by my statements to the court in context are that whatever defenses Key has, they still have. They didn't lose any of their defenses. And to the issue of can they contest liability? Can they contest damages? They can contest them in the context of their good or bad faith. That the reason the court got this wrong is that the court did not know about fact witnesses. The court did not know about damages. The court did not know about mitigation. And if they show that to the court, then it's collusion, or I forget what Justice Rosen wrote in his, but
Concocted.
If they prove this is concocted, it all goes away. If they show that we misrepresented liability, and not that someone couldn't get a different answer or a different percentage, that's different than what they have to show. It's that we concocted this, and they have taken depositions. We have been in depositions all through COVID. They have talked to the fact witnesses. They have redeposed my clients. They have filed motions to strike expert witnesses to show that what the judge did was rely on a concocted set of facts. If they win that argument, they are not responsible for this judgment. If they
Let's not, just so you know, Judge Rosen wasn't saying that the concocted set of facts. He's talking about a procedure that was concocted. He didn't say collude or anything, just that was designed to shut out the insurance carrier from raising things like comparative fault and damages.
Counsel, your time's expired unless you want some final statement there.
No, thank you, Your Honor. I appreciate the judge's time and
Okay.
getting used to being on Zoom.
All right, very good. Counsel, you're on, there we go. You were muted there for a second. You've got your 5-minute rebuttal time.
Okay, thank you, Your Honor. And I'm not sure if I'll even need the full 5 minutes. What Mr. Leatherman is talking about and what we were entitled to are two entirely different things. He is saying that we have the opportunity now to come in and prove collusion, to show that we reasonably relied on what these witnesses told us in determining that we weren't willing to settle at a particular time, or that we needed additional information before making that decision. That's one thing. That goes to the defense of the allegations against Key Insurance Company that it negligently or in bad faith failed to settle the underlying case. An entirely different thing is Key's contractual right under its policy to defend the lawsuit against the insured. And I think that's what Judge Hill was getting at in pointing out that we're talking about separate issues. Key should not have to come in and prove collusion. Key should not have to only be able to present these issues in the context of a bad faith case, to quote Mr. Leatherman. What it should have had the opportunity to do was defend the wrongful death lawsuit. That's what its contract of insurance gave it the right to do. And through this agreement, it was deprived of that ability. Through the denial of its motion to intervene, it was deprived of that ability. It should have been able to come in and, instead of it being a one-sided presentation of evidence, present both sides of the case. And quite frankly, it should have been able to do that not in a trial to Judge King, but in a trial to a jury if it chose. And Judge King only got one side. Key was never able to present the defense side of the case. It's possible.
My question to you, counsel, is, hey, you had a right to appeal that, didn't you? And you had a right to post a bond to stop all of that for an appeal bond, correct?
Well, Your Honor, I think we have preserved it. We have appealed the denial of our motion to intervene. Now, the appeal bond, in my mind, would stay not the case, but execution on the judgment that was ultimately entered. And
we used to call them supersedious bonds.
Right.
Yeah, and so it would preserve the asset of whoever had a judgment.
Right, but it would not prevent that judgment in the first place. And so to say that we needed to file an appeal bond to prevent that judgment, or a supersedious bond, that doesn't quite make sense to me, because that would come after that appeal necessarily, or after that, the entry of that judgment necessarily, rather than before the entry of the judgment.
But doesn't it call into question whether that judgment remains final? Because say on appeal, we rule that you had a right to intervene, we can set that judgment aside. Isn't that the relief you're asking for?
Yes. Yes, Your Honor.
And it's the same relief, except now you've got a garnishment action over here that you're having to defend, and a supersedious bond would have prevented all of that, correct?
I think if the judgment is set aside or vacated, I think that moots the garnishment action. And what would then happen, as I see it properly playing out, is we have a chance to present the defense to the wrongful death suit. If it could be that the Judge King or a jury finds zero liability for Ava Mercer, or finds the decedent more than 50% at fault, and there's no judgment. It could be.
Now,
that
you aren't
there's
asking us to get into some dicta in this case, are you, counsel, for the case in front of Judge King?
No, I'm not. What I'm doing is laying out what I think would be the proper procedure going forward. But the first step would be reversal of the denial of our motion to intervene and vacating that judgment because the denial was improper.
Why couldn't you have asked the district court to stay the proceedings pending the appeal on the motion to intervene?
Because we were not a party to request a stay.
Well, why weren't you? You'd filed a motion to intervene, and that's a final appealable order. So why wouldn't you be in a position to ask the district court to stay?
I think our motion to intervene would have to have been granted in order for us to have standing as a party to seek a stay of that case. When the motion to intervene was denied, we remained effectively a stranger to that lawsuit. We were not a party to it. We were asking to come in, but we were not allowed.
But then you filed a notice of appeal, and you could have asked this court to have entered an order of stay of the court of the proceedings below, and you did not.
No, and I do not read the cases or statutes as requiring that in order to preserve the issue we've raised on appeal or the relief that we're requesting.
But don't you understand you had the right to ask this court to stay the proceedings below under Supreme Court rule?
I suppose possibly we could have.
All right. Thank you.
Counsel, that your time has expired. I want to thank both of you for very interesting oral arguments here today. It's a fascinating case, and we'll take it under advisement and get you an opinion as soon as